discuss this application process. That's probably the most tedious and technical of it all, and I swear I think it's rigged. So nobody from Social Security will ever tell you that. They will give you all sorts of rhyme and reason for why they put you through this, but my personal belief as an advocate is they're making it difficult because they're overworked, they don't have enough funds, and they're putting us through this process just to catch up. But you file an initial application at the local Social Security office. You can find your local Social Security offices by going to SSA.gov and just putting in your zip code. You can do this by going in person in the office, or doing it over the telephone, or you can do it online. If you do an SSI application, you cannot do it online. They need to speak to you, or they need to see your face. I really recommend that if you're going to do this in the office in person, call them ahead of time, make an appointment. If any of you have ever sat around in a government office here, you know what I'm talking about. You don't put yourself through that. Make your appointment, go in, take with you any medical documentation you have that speaks to your diagnosis or your symptoms. Some of you, if you don't have a diagnosis yet, you can still take with you records of you complaining about your symptoms to your primary care or your specialist. But take something in with you. Do not count on Social Security doing this work for you, especially with KLS. This is something that is way above their head. They are not, their local workers are not going to spend their time researching this. You're lucky if you find that kind of an adjudicator, but you won't find it. It's going to be a quick rubber stamp denial, basically, is what I'm telling you. Few adjudicators will take the time to educate themselves on the application and the disease that's before them. But the other question, the issues that you need to be aware of during the initial application is your work history. They're going to want to know what kind of work you engaged in the past 15 years. And when I say 15 years, I'm talking about 15 years prior to your date of disability. Your date of disability, I know, is difficult when we're talking about a disease like KLS, where you don't exactly know when it was diagnosed, or was it at birth, was it later on. Typically, if it's for an adult, we look at time when the individual decided, I can no longer work. I'm just not being able to be productive at my job, or we got fired. If we're talking about a child, we either need perhaps a point in time that if the diagnosis was made, a point in time where the records are just become overwhelming. And that may be more of a legal issue that the attorney and the judge at the hearing have to hash out of exactly what is that turning point that we meet the definition of disability as far as the medical evidence goes. So you want to have that work history with you, you want to have doctor's records with you, you want to have an understanding of what your day-to-day looks like. They're going to ask you about your daily life functioning and how you cope throughout the day, how you can take care of yourself. More importantly for KLS, they're going to want to know about the frequency of the episodes, how long the episodes last, any recovery period that is associated with any other associated symptoms. So I always tell my clients, keep a journal, document everything as much as you can. Hopefully you won't have to go through this process, but if you do, it'd be really good to have everything documented. It will also help figuring out your date of disability, because your date of disability will coincide with how far back Social Security will give you as far as back pay goes. And I'll get into that in a little bit. So we'll file the initial application. 3 to 5 months later, we usually get a decision. That decision typically is a denial. It's an overwhelming number of people that get denied. And that decision is very informal. It's very impersonal to you. It sounds like nobody even looked at what you told them. Nobody even reviewed them. It's very much, well, we find that although you said you can't, drive a truck anymore, you could still go be a teacher. Or just something really nuts up like that. Like, what are you talking about? But it's really just a standard language that I think they have a template on. They're just plugging in the information and just spits it out for them when they issue it. Once we get that initial denial, we have 60 days to file an appeal. We want it in our office, we do it right away. We have 60 days, but this is going to be a 2-year process. Why do we want to sit around for 60 days to file an appeal? So we file it right away. It's called a request for reconsideration. And at that level, if they haven't already sent you to one of their own doctors, they may send you to one of their doctors that basically will examine you and just have a conversation with you about what your functional limitations are. And listen, if you had back problems, that appointment might have been helpful to you. It might be helpful to see a doctor from Social Security side that asks you to bend over, maybe asks you to raise a leg, whatever. With what you guys are dealing with this appointment, it's going to be completely useless to you. And it's going to reveal probably nothing to Social Security. Already the medical industry is so far behind on research and understanding what's going on with KLS. So imagine these government-funded doctors, what knowledge are they going to have about it? Because they really don't have any resources to research this and look into your specific issue. Usually these are just generalists that they send you to. But you need to really, they ask you to go to the appointment, you need to go, otherwise they'll give another quick denial just for non-compliance. We typically expect a second denial at that reconsideration level because it's gone back to the same hands. And I'm telling you this not to discourage you, I'm actually telling you this to encourage you to not get a denial and just stop right there. You have to keep going. And when you get that second denial, then you need to ask for a hearing with the administrative law judge. And that's where the hearing comes in. And in Georgia, in Atlanta right now, we're looking at about 12 to 14 months from the time you ask for a hearing to actually get a hearing. So this is really where I'm talking about a 2-year plus process kicking in. Most people that have a good case, they win it at the hearing level. They win their case at the hearing level because the judge really seems to pay attention to what's going on. But if that still does not result in a favorable decision, then we can appeal higher to the Appeals Council in Falls Church, Virginia. It's a tribunal judge that sits there, and basically they review whether the judge made the decision in accordance with the law or not. They have an option of reversing the judge's decision, remanding it back from the judge's decision, or just denying it altogether. That's not a very easy process to overcome, so hopefully, you've won your case in the hearing process. And if you still get denied at that level, you've really exhausted all administrative processes, and then you get to have a lot of fun and sue the whole agency in U.S. District Court. I'm kidding, it's not fun, but it is an option.